Mr. Morgan, we'll get started in 1 second. Okay, I was just making sure we got our YouTube connection, which I should have started up earlier, but we've got that. Ms. Hilton, there is someone on our call with just the name Lucky. Is that someone that you intend to have join us?
No, I don't believe we're going to have anyone on the call today, so that should not be for us.
All right. Lucky, can you let us know who you are?
Judge, let me interrupt. I think that may have been Officer Lucky for this morning case with Mr. Brandon. I'm not sure, but I think that's probably who it was.
Got it. Okay, that's fine then. Thank you for flagging that. The name, like, I had Lucky earlier, so it may be that she had plugged in briefly for that gentleman, and she may just be AFK, as they say. But I think we can move forward. So let's go on the record in case 20 SD 175064. It's State versus Morgan. We have Ms. Hilton on the Zoom session representing the state of Georgia on behalf of Ms. Sims. And then we have Mr. Morgan here in court. Good morning, Mr. Morgan. And he is represented by Ms. Snyder, who is also here in court. And it's my understanding, Mr. Morgan, that you are prepared to go forward with a plea in your case. Is that correct?
Yes.
Okay. You are on the trial calendar that we are in the midst of, and you were on deck this morning, actually. There's another judge picking the jury, but if that doesn't go forward, we certainly have as a fallback 60 potential jurors across the street if we need to do that with this case. So, Ms. Snyder, is this a negotiated plea or non-negotiated?
It's a negotiation, Your Honor.
Right. Ms. Hilton, I have a copy of the indictment here that I will sign on behalf of everyone, assuming they agree to that at the end of our proceedings. But otherwise, I will let you take it from here. Oh, one last thing, Mr. Morgan. Ms. Hilton is going to put you under oath in just a moment. Once you're under oath, it's important that you answer her questions and mine. We both have some questions for you, truthfully and completely. If at any point while we're having our conversation, you don't understand what someone's talking about, or you can't hear them, or for whatever reason you want to speak privately with Ms. Snyder, let me know and we'll make that happen, okay? All right, you make sure you speak up because Ms. Rivers, the court reporter sitting right in front of me, needs to be able to hear you, but also Ms. Hilton, who is remote, needs to hear you. The microphone will pick it up, but you're going to need to belt it out a little bit, okay? All right. When you're ready, Ms. Hilton.
Thank you. Mr. Morgan, if you could please raise your right hand. Do you solemnly swear that the evidence you shall give in the matter now pending before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hands down. Please state your true and correct legal name.
Shabazz McBurney.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you?
45 years old. 45 years old.
And how far have you gone in school?
I went to the 11th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses in this indictment? Aggravated battery, which you are charged with 3 counts of aggravated battery. Do you understand that?
Yes, ma'am.
And you're also charged with 1 count of aggravated assault,
Yes, ma'am.
1 count of battery, family violence, a misdemeanor.
Yes, ma'am.
Excuse me, a felony. I apologize. And then 1 count of violating a family violence protective order. Do you understand those are the charges in your indictment?
Yes, ma'am.
Do you understand you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Your Honor, in your division, do the defendants do the waiver of rights form?
So we have a form, we have not begun to roll it back out just because we're still working through the logistics of lawyers being with their clients. So at this point, you don't need to verify any signatures because I have not been asking the attorneys to have them filled out for their client.
Okay, I just wanted to make sure.
Yep.
Have you had enough time to speak with your lawyer, Ms. Snyder, about all the facts and circumstances known to you regarding charging this indictment?
Yes, ma'am.
And have you spoken with her regarding any potential defenses?
Yes, ma'am.
Do you need any more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Do you waive formal reading of the indictment?
So
Yes.
wait,
Okay. And do you waive any and all defects, if any, with respect to the indictment?
we are unaware of any defects for the purpose of this plea, so wait.
Okay, thank you. Have you been advised of the minimum and maximum sentence for each charge that you are pleading to?
Yes, ma'am.
Okay. And so you're aware that for aggravated battery, for each count, that's a sentence of 1 to 20 years?
Yes, ma'am.
And for count 4, the aggravated assault, that's also a sentence of 1 to 20 years?
Yes, ma'am.
And for count 5, which is a felony battery family violence, that'll be 1 to 5 years?
Yes, ma'am.
And then count 6, which is violating a family protective order, which is a misdemeanor, which is 12 months and or $1,000 fine.
Yes, ma'am.
Do you understand that in this case, you're going to be pleading to 1 count of aggravated battery and 1 count of aggravated assault?
No,
Is that your
ma'am.
understanding?
No, ma'am. It's supposed to be 1 count of aggravated battery.
Okay. Do you need more time to speak with your attorney about the other count of aggravated assault that you'll be pleading to?
Yes, ma'am.
Okay.
All right, so we'll pause for a second and you can probably talk right there. Just want to turn away from the table.
So she can-
So the question, Mr. Morgan, was that your understanding that you'd be entering a plea to one of the aggravated battery counts. Do we know, Ms. Hilton, which of the 3?
He would plead to count 1, aggravated battery, and
And then-
count 4, aggravated assault.
Right, so it's 2 counts, aggravated battery and aggravated assault. Are you now comfortable with that being the situation you're moving forward with, Mr. Morgan, or do you disagree with that?
I'm moving forward.
Okay, so you understand that in just a moment, Ms. Hilton is going to be asking how you plead as to counts 1 and 4. It sounds like the state will be dismissing the other counts in the case. Understand that?
Yes, sir.
Okay.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence. As to count 1 of the indictment, switch screens, 5 years to serve 2 years, commuted to time served, balance on probation. Do you understand that?
Yes, ma'am.
And as a special condition, you're supposed to have no contact with Frederick Hill, that you're to undergo evaluation for substance abuse and mental health, that you are to comply with all treatment recommendations, and that you're to have no weapons, specifically no knives. Do you understand that?
Yes, ma'am.
Okay. As it relates to this negotiated plea, Counts 2 and counts 3 will be null pros, meaning dismissed by the state of Georgia. Count 4, you will plead to 2 years commuted to time served. And counts 5 and count 6 will be null pros, also being dismissed by the state. Do you understand that?
Yes, ma'am.
Do you understand that the court does not have to accept that recommendation?
Yes, ma'am.
And the court can sentence you to the maximum on each charge and can run those charges consecutively, meaning one after the other. That's what the court could do. Do you understand that?
Yes, ma'am.
Do you understand if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
You said yes, ma'am?
Yes, ma'am.
Okay. Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes, ma'am.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up those following rights?
Yes, ma'am.
And I'll go through them specifically. The right to a trial by jury,
Yes, ma'am.
the right to remain silent and not incriminate yourself,
Yes, ma'am.
the right to confront witnesses against you,
Yes, ma'am.
the right to assist of counsel hired by you or to court-appointed counsel if you cannot afford an attorney,
Yes, ma'am.
the right to the presumption of innocence,
Yes, ma'am.
the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
the right to have the charge against you proved beyond a reasonable doubt,
Yes, ma'am.
and the right to appeal if convicted of these charges.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
With respect to this indictment, 20 SC 175064, how do you plead to count 1, aggravated battery, and count 4, aggravated assault?
Can I plead no contest? Not all, please. Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes, ma'am.
I know that you just asked if you can plead nolo. I know you just spoke with your counsel. Are you moving forward with your guilty plea?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
I only have, it should be appealed.
I'm
So-
sorry, sir.
So what Ms. Hilton is about to cover with you is your limited set of appellate rights. By entering a guilty plea, you still have some appellate rights. It's just different than if you went to trial and were found guilty. So she's going to tell you in just a minute that you've got 4 years in which to do certain things and a certain window of time to do things. So listen to what Ms. Hilton has to say, and if you've got questions about that, we'll answer them. Okay? All right.
Just as the judge said, you have 4 years from today's date to file a habeas corpus petition with respect to this guilty plea. Do you know what a habeas corpus petition is?
Oh, ma'am.
Okay, that you'll be able to challenge the voluntariness of this plea within 4 years of today's date. You understand that?
Yes, ma'am.
And in understanding that, do you want to talk to your attorney a little bit more about a habeas corpus petition?
No, ma'am.
Okay. With knowing that you understand that you have 4 years from today's date in order to file that petition to challenge the voluntariness of this plea.
Yes, ma'am.
All right. And Your Honor, at this time, I'll go over the factual basis as a result of this plea.
Okay,
Your Honor, this is an incident that occurred on February 1st, 2020. The victim in this case is Mr. Frederick Hill. Both the victim and the defendant were previously in a relationship and at times lived together. On the incident day, the victim and defendant were walking down the street. This is near Peachtree and Pine or down Piedmont Road, kind of in that general vicinity. And during the course, the two were in a verbal argument. At that time, Mr. Morgan pulled out a pocket knife and stabbed the victim in the face, his hand. When officers arrived, they did see the defendant on top of the victim. Also, there was an independent witness who wanted to remain anonymous, who told officers that the defendant stabbed the victim. The victim was treated by Grady medics and then transferred to Atlanta Medical Center. Due to the injuries, the medics were unable to get a pulse in the victim's hand initially. Your Honor, in preparation for this case, we did go out to seek and find the victim. The victim is homeless in this during this time, and so we've been having some challenges locating the victim. However, based on what we know from the officers, what they saw and what this independent witness saw, we move forward with the case. Mr. Morgan has been in custody since his arrest on February 1st, 2020. He has spent a total of, I believe, as of today, 458 days in custody. He does not have any felony convictions. He does have a few cases that were, he received first offender and conditional discharge. So as of his record, he does not have any felony convictions. He does have a history of a lot of battery and family violence cases, Your Honor, that brought the state some concern in looking at and evaluating Mr. Morgan's history. However, we believe given the current circumstances, this is the best resolution at this time, Your Honor.
okay. Ms. Crawford, do you have any felony criminal history for Mr. Morgan?
No, Judge, he does have that first offender and that's it.
Okay. I did notice in connection with count 6 of our current case, there's a reference to a 19 SC indictment. I looked that up. It ended up being misdemeanor. Things were reduced to a misdemeanor, but a fairly similar set of allegations down to Mr. Hill being the victim. So it does sound like Mr. Morgan and Mr. Hill had something of a tumultuous relationship. The storyline for the 19 SC case was that Mr. Morgan was actually just helping Mr. Hill out after Mr. Hill had been assaulted by someone else with a bottle. But the allegations were, once again, Mr. Morgan stabbing Mr. Hill. But that was again reduced to a misdemeanor and it's not in the case anymore, it sounds like. All right. Ms. Snyder, what did you want to share?
Mr. Morgan is 45 years old. He works with his uncle in a floor cleaning business. When he is released, he will go live with his sister until he can get back on his feet and in his own place. Previously, he was unmedicated and has been, once he was arrested, he was evaluated for the GROW program through Grady and was accepted into that. And it is our understanding that he is still eligible for that program, but we wanted to leave the treatment choices up to his evaluation through probation so they could work out the best way for him to get his treatment, but not require him to do a program that may or may not have different circumstances. So we would ask that you accept the plea as negotiated.
Okay. Mr. Morgan, when was the last time you saw Mr. Hill?
The day that this incident was supposed to happen.
Okay, so February of last year.
Mhm.
Have you been in touch with him since you've been in custody?
Mhm.
No phone calls?
No,
He hasn't come to visit you?
no.
Where does your sister live?
I'm Martin Luther King.
Does she know that you are hoping to live with her when you get out?
Yeah,
How does she know that?
I've called her.
And she told you that's okay?
Mhm.
How many people live in the apartment with her?
One,
She lives there and one other person lives there?
yes,
Who is the other person?
her son,
How old is her son?
20 years old.
So an adult son.
Yes, sir.
Does he know you're coming?
Yes, sir.
Does your sister work?
Right now she's disabled. She was in a car accident and she's doing better, so she works when she can, but right now she's disabled.
She's working through the injuries sustained.
Mhm.
Does she expect to be back into working shape soon, or it's hard to tell?
It's hard to tell. I mean,
I'm sorry for that. Does her son work?
yes, sir.
What does he do?
He works at a public grocery store.
Okay. And then Ms. Snyder mentioned you work for a floor cleaning business,
Mhm.
and that's your uncle's or your
My
father?
uncle, my uncle,
Your uncle's. And does he own the business or he works there too?
he owns the business.
And have you talked to him since you've been locked up?
Not since I've been arrested, no.
Why do you think he'll take you back?
Because he knows at this time I'm trying to get myself together. I'm trying to get away from people, places, and things. And I'm a pretty good worker, so I'm pretty sure I'm almost positive with it.
Have you worked for him before?
Yes, sir.
What's the longest period you worked for your uncle?
Worked for him for a couple of years.
Consecutive years. You mentioned people, places, and things, which is an important phrase and concept for people who've been in treatment before. Have you been in addiction treatment before, or is that something you've been doing in jail?
Now, growth is where I had been in treatment before, and that's where I got the phrase from, people, places, and things.
How long were you in treatment with Bro?
Well, about 2 years.
Is Mr. Hill someone who is important enough in your life that you think there's a chance you're going to try to reconnect with him?
No.
Why do you say that?
Basically, he's a friend of mine that we share an apartment together. We share like hotel rooms together. And we also drank together and got high together. My mom is saying that. It's something that I'm not planning. I'm not planning on going back to that type of environment. So I don't believe that he's going to be a problem with stay away from Mr. Hill because he's we're not going in the same direction.
Okay, well, I hope you are able to go in the direction that you described. Mr. Morgan, do you have anything you want to share with me? Beyond me, I appreciate your answers, but I need to make sure you have an opportunity to say anything if there's anything you want to add.
So,
Well, I find there's a factual basis for your plea. It sounds like you and Mr. Hill have had an up and down relationship over the years. Maybe that's behind you now. I hope it's behind you now. You're still young, 45, you've got lots of years ahead of you, but you're old enough, I hope, to know that there are people and places that nothing good comes out of that. You are with them or you are in those places. But you need to make those decisions as you try to move forward. I also find that your plea is knowing and voluntary. A knowing plea means you've understood the things we talked about. And if you didn't, you ask, like you did about habeas corpus. Do you have any other questions about anything you described?
No, sir.
All right. A voluntary plea doesn't mean enthusiastic, but it does mean that it's a decision you're making because you think this is the right way to move forward. And no one has forced you to enter the plea or promised you anything other than the offer that the state has made. Does that describe your situation?
So,
All right. Then I will accept your plea. I am going to sentence you pursuant to what's called the Probation Options Management Act. And all that means, Mr. Morgan, is that while you're on probation, which you will be for a while, if you have a technical violation, something that's not real serious, you and probation will sort that out. You don't have to come back in front of me. But if it's more serious, you get arrested again, or Mr. Hill is contacting the DA's office saying this Morgan guy won't leave me alone, then we'll need to have a conversation about that to figure out what's going to happen. Okay? Do you understand that?
yes, sir.
All right. Mr. Morgan, I am going to sentence you on count 1 to 5 years to serve 1 year and 4 months with the balance on probation. You will get credit from February 1, 2020. And on count 4, the aggravated assault, I'm going to sentence you to 1 year and 4 months. That will run concurrently with count 1, meaning at the same time. It will be a special condition in your probation that you have no contact with Mr. Hill. That obviously means you don't go seek him out to be in the same space. If for some reason you end up being someone who's active in social media, you're online, you learn about how you can contact him indirectly, calling or texting or something, that would also be contacting him. You need to not do. Mr. Hill goes his way, you go your way. If you happen to be somewhere where you see him, it probably means you're not staying away from places you should stay away from. You gotta walk away. Understood?
Yes, sir.
All right. There'll also be a special condition of your probation that you submit to a mental health and drug and alcohol abuse evaluation. And if the medical professional who conducts that evaluation recommends any treatment, you have to follow that course of treatment. In particular, you're going to be required to take any medication that any medical professional prescribes. So if you're seeing a good doctor at Grady, and she says you need to take X to help keep you stable or this or that, and you aren't taking it, that's going to get you sideways with probation. The medication is prescribed to help you make the decisions you want to make and stay out of the situations you found yourself in the last few years that left you stuck in jail for a bunch of months. Okay. Do you have any questions about any of that?
No, sir.
All right. Ms. Hilton, anything else? I know you had mentioned no knives. I'm not going to make that a condition because Mr. Morgan could go to a restaurant and I'm not going to have to tell the folks at the restaurant I can only have a fork or a spoon. Mr. Morgan needs to not have a weapon around him if he's feeling like he's getting agitated or getting into an argument with someone. But anything else you want to add?
Nothing else from the state, Your Honor.
Okay. Ms. Snyder, do you have anything else?
Yes, sir.
Mr. Morgan, the sentence that I imposed is slightly different than what was negotiated. The 2 years reduced the time served gets you out in a couple days. 1 year and 4 months, which is a more precise and it's not reduced to, keeps you in for a few more days, but it's literally days. I just rounded it to the closest month. But that's what I'm going to do. Just wanted you to understand I wasn't ignoring what anyone had requested. We need to get a good address for you. Ms. Crawford, the probation officer you're going to see on the screen in front of you is going to need to know your sister's address. Do you have that memorized?
No, I don't.
Okay.
I can call her.
Okay, is that something you can get to Ms. Snyder so she can get it to probation?
Mhm.
Ms. Crawford, are you going to have a report date that we can write down and give to Mr. Morgan?
Yes,
Or
Judge.
can you do that without an invoice?
I can give him a report date and I will get the address from Miss Snyder when she's able to email it to me. The report date will be May 25th of this year at 10 a.m. Do you know if your sister resides in Fulton County, Mr. Morgan?
Yes, ma'am, she does.
Okay, so you will report to 276 Memorial Drive, Southwest. That's Atlanta, Georgia. The zip code is 30303. So that'll be 525 at 10 a.m.
Did you get that, Ms. Snyder?
Yes, sir.
So, Mr. Morgan, Ms. Snyder's gonna leave you that piece of paper. If for some reason you lose it, you forget, reach out to Ms. Snyder, so you don't miss that first appointment. If you're not there at 10, they will probably reach out to me saying, Mr. Morgan's already having some trouble, we think there may need to be a warrant. It's real important that you start out on the right foot with this. We would love to see you head in the direction you find you want to go, working for your uncle, and staying out of harm's way. I hope you want the same, right? Anything you want to add?
Okay, when you said 1 year and 4 months, is it like, how long will it be before I actually get out?
1 year and 4 months is 480 days. That is 22 days from today.
Wow, then there's no way I could get out before the end. I didn't think it would take the reason, but I didn't think it would take that long. Did you make it 3.5 months or something like that? Because I was really expecting, I had people expecting me to be out so that I can get my, my place of living and water and things. And so is there any way possible that this could happen sooner than this?
I think this is the right outcome in light of the case you had only a couple of years ago involving Mr. Hill and the nature of these allegations. So that's going to be the way it plays out. I'll tell you this, the sheriff's office cannot let you out any later than that. They may well let you out before then because you've done well in the jail. They may look at your situation and get you out tomorrow. There's nothing that prohibits them from doing that. It's not a mistake by the sheriff's office. They just would have to let you out no later than the 1 year and 4 month mark. Okay. Oh, I have one last thing. I have a copy of the indictment. And I can't remember if Ms. Hilton asked you this, Ms. Snyder, but you waive any issue for proceeding off a copy of the indictment.
Yes, Your Honor.
All right, and then do you authorize me, Ms. Snyder, to sign your signature on the indictment?
Yes, sir.
I'll make sure to indicate that all those counts are being dismissed on the indictment. Ms. Hilton, do you authorize me to sign the indictment on your behalf?
Yes, Your Honor.
And Mr. Morgan, do you authorize me to sign the indictment on your behalf? So we don't need to pass these papers around.
Yeah.
Pardon me?
Yes.
Okay, thank you so much. Ms. Hall, I think we are in a position to chat about whatever you want to chat about.
And Your Honor, on an unrelated matter, I'm sure you are aware Ms. Sims has left the office.
I will tell you, we've been in a little bit of flux. I know we don't call it CWAC anymore. It's broken into a few pieces, but Ms. Patel is taking a break, but will be coming back. And I'm trying to remember who else we had, but so Ms. Sims, so she's gone to be somewhere else.
Yeah, so Ms. Besa will return. So that is who is actually assigned to your courtroom. Ms. Besa will return in July. I will be covering until we find a replacement for either Ms. Sims, but I'll be here for the next at least 30 days.
So Ms. Sims didn't get reassigned. Ms. Sims is no longer with the district attorney's office.
Correct.
Okay, and so Ms. Besa will be back, but is she taking the same kind of break that Ms. Patel is taking?
She is.
Okay, great. That's just apparently in the air for the DA's office. I hope everything's going well for her. And
It is.
Ms. Patel. And then is it right, Ms. McCauley is going to be covering for Ms. Patel?
I believe Ms. McCauley will be covering for Ms. Patel while she's
I'm
out.
spoiled with you and Ms. McCauley covering. I can handle it. I mean, people want to take breaks like that, they should do it. But I wish them all the best. And if you would please, Ms. Hilton, just keep Ms. Nelson posted if there's going to be a different interim person covering for Ms. Beza. We're going to look to you until we hear otherwise. But if you find out it's going to be person X, just let Ms. Nelson know. Obviously, Ms. Hall as well, because Ms. Hall is our point person. If we've got a case on the calendar and we can't track down the specialized folks, or Ms. Hall takes it on the chin, she needs to deal with it. So she'll want to know as well. But we're excited to have you helping out as long as you're able to help out.
Yes, so I will be here, but I will surely keep Ms. Nelson and Ms. Hall abreast of any changes that's going on in our unit.
Okay, sounds good.
All right, have a good one.
All right, bye-bye. All right, Ms. Hall, what's going on?
So, Your Honor, I just wanted to get clarification from you since I have never, excuse me, we've never really dealt with the state in your courtroom withdrawing a petition. I just want to know the procedures of how you want that or how that should be done in your courtroom. I know in other courtrooms, ADAs are able to pull their warrant or withdraw our petition that probation files, but I'm not sure how that works in your courtroom. So I just wanted a clear understanding because tomorrow I have the same issue that we had today with the right defendant.
Got it. The shooter. Okay.
Yes.
So here's how I understand it, and we can develop an approach. I wasn't trying to be difficult, and I certainly didn't feel like you were.
Oh no, you weren't. You weren't
usurping my role or something. But the warrants, the petitions are issued by the Department of Community Supervision, not by your office. Every once in a while, they come from your office. In particular with drug court, I'll get petitions that Ms. Collier has actually written, saying, hey, we want to revoke this person. And you may have done that every once in a while. That is seldom, because it's usually it's a suspended sentence, and your office is saying, hey, this guy did this new thing, and we want to resurrect that suspended sentence, try to revoke some of that. Perfectly appropriate. And if that's how the case came to me, through paperwork from the district attorney's office, for you,
I'm gonna stop you. I'm gonna stop you because I don't want you to keep wasting your breath. You're going in and out. Can you try turning your microphone off like you did earlier?
Okay, it is off. Now it's on. Is this better or worse?
No. Go back to where you was at. It's just it sounds a little muffled. I'm catching most of what you're saying. I just didn't want to I wanted to make sure I caught everything.
All right, well, I'll be more to the point. When it is a petition from probation and not from your office, I think the only role you have in it is to say, I'm ready or I'm not. And if you're not ready, then any judge would say, well, if you're not prepared to go forward, then I, the judge, am dismissing the petition. But I think technically, I'm not critiquing any other judge's approach, only probation or the judge can dismiss a petition from probation. Probation could say, we made a mistake, we don't want to do it anymore. The judge could say, the state's not prepared to go forward, so I'm going to dismiss it. But I don't think the state can come in saying, we are dismissing, because it's not the state as in the district attorney's petition. Does that make sense?
That makes sense. So a follow-up question, when you do dismiss it, if I'm not prepared to move forward, is that with prejudice or can we bring it back when we're prepared? It
is just, I don't believe it's with prejudice. I think I would say it's dismissed, the warrant is lifted, and then you could always, and you probably wouldn't bring it back to the probation, but you're always free to file a petition to revoke someone's probation. Every once in a while, the DA's office does that, but you'd want to work with Ms. Crawford and whoever in this case would have been Officer Lucky for this guy we had this morning, if you were trying to resurrect it. In general, we shouldn't wait until the day of if you know you're not going to go forward. And I say you're not ready to go forward. You could choose not to go forward. You say, you know what, we will not be presenting any evidence in this petition. And if you know that in advance, you just tell Ms. Nelson the state isn't going to be going forward with that.
Okay, great.
And then I can tell everyone, well, then I'm dismissing it because the state's going to have nothing to say.
Okay, great.
That may seem like semantics, but it is a distinction with a difference.
I understand. That's exactly, I spoke with Ms. Nelson about this, but because I didn't know which way to move, I didn't know if I should do it before court email or in court announcement. So thank you. I
Yeah,
will be
and
sending
you don't
emails
need to
today.
wait till court. If you know in advance that for whatever reason, you're not going forward with one, just share that with Ms. Nelson. It'd be helpful to know why. The officer, you can't find an officer, you can't find a victim, or you don't have to say why. But if you're not going forward with it, then if it's a non-technical, then I'll probably say, well, then it's dismissed. If it's a technical violation, sometimes probation still wants to go forward and they can prove up their own petition. That's what happens out at the jail county. That
Right.
probation proves up, hey, he didn't show up for his meeting, or he tested positive for marijuana, or he hasn't taken his GED classes. If it's new charges, it's really the only ones we really are struggling over. That is obviously 100% you. The probation folks can't do anything with new charges other than take petitions out.
Right.
Those are ones where I'll probably want to understand why your office isn't moving forward, because the whole point of doing those is we can often resolve the new case and the old case if the new charges have some meat to them. Because I'm going to revoke a pretty significant chunk of time if you show by a much better burden for you, yeah, the police arrested this guy and he had drugs in his pocket. There's no suppression issue. The officer says there were drugs in his pocket, then he's probably going to get hit pretty hard with a revocation issue, and then maybe he's going to just say, I'll plead to the accusation, but that's assuming you're able to bring an accusation.
Understood. Thank you, Your Honor, for clarity.
You're
I
welcome.
understand everything.
All right.
Hey, see you tomorrow.
All right. Bye-bye.
Bye.
Thanks, Ms. Nelson.
You're welcome, Judge. Did you have a good birthday?
Yes, thank you for sharing. I did.